What's in the Georgia real estate purchase and sale agreement? Let's take a look. Alrighty, here we go. First of all, this is investing in Georgia. This is all Georgia specific information. This right here is the Georgia Association of Realtors purchase and sale agreement. So obviously this is Georgia specific. We usually talk about building, fixing, buying, and selling real estate. I am an investor, licensed contractor, and realtor. And my contact information is in the description below if you have any questions. So let's go in. If you are looking to sell your house or purchase a house, this is the contract that you are going to have to go through. Purchase and sale agreement, offer date, got the address, legal description, the purchase price offered, the monetary contribution toward buyer's costs at closing offered, the closing date and possession. This is when when the actual transaction would occur. And possession, generally do it at closing unless there's some other specific reason. Closing law firm and holder of earnest money. Generally make it the attorney. It's just simpler. And how much deposit. So if you'll notice, a lot of this stuff filled out is going to be on the front page. Then inspection and due diligence is going to be the inspection period. All right. And lead-based paint, if it was built before 1978, you have to circle that or check that. For simplicity's sake, I'm going to say everything should be represented as a client. Unless you are familiar with all the other types of agency, you should be represented as a client. Then this is any material relationship disclosure, like if an agent knows someone involved in that, etc. They're related or whatever. Time limit on the offer. This will be opposite when the offer expires. And on the date, and the buyer's initials and the seller's initials if they choose to accept. Purchase and sale warranty. Seller warrants that at the time of closing should convey good marketable title. And buyer agrees to assume responsibility of any leases. All right. Examination. Buyer may examine title and or obtain the survey of the property and furnish seller with a written statement of the objections prior to closing. If seller fails or is unable to satisfy valid title objections at or prior to the closing of any unilateral extension thereof, which would prevent the seller from conveying good or marketable title of the property, then buyer, among its other remedies, may terminate this agreement without penalty upon written notice to seller. I have another video on the cost paid by who pays for what in a real estate transaction. You should watch that. It has a little more detail on this. Prorations, you have the city, all the taxes, all the stuff are prorated. Closing date, you right to extend closing date. You have 8 days. Generally, there's a lot of reasons either side can extend it for 8 days. I'm not going to get into all the details on that. You got to include all keys, garage door openers, etc. Anything that's generally considered with the house is going to go there. Closing law firm. Buyer shall have the right to select the closing law firm, holder of earnest money, and that's the attorney. Entitlement of earnest money. Subject to the paragraph below, buyer shall be entitled to the earnest money upon failure of the parties to enter into a binding contract, failure of any unexpired contingency or condition to which this agreement is subject, or termination of this agreement due to the default of the seller, or termination of this agreement in accordance with the specific right to terminate set forth in this agreement. Otherwise, the earnest money shall be applied toward the purchase property of closing. If other funds are used to pay the purchase price, the earnest money shall be returned to the buyer. The buyer's right to inspect property. Obviously, you have the property is in as-is condition, as in Georgia law, and with any and all faults. Therefore, the buyer and buyer's representative have the right to carefully inspect the property to make sure it meets the needs of the buyer. So you can check to see if it has been a meth lab. And you inspect the neighborhood as well. This is if you're the sex offender list. Buyer's inspection indemnification obligations. Buyer agrees to hold seller and brokers harmless from any claims, injuries, and damages related to the exercise of inspection of the property. And buyer shall promptly pay seller the actual cost to restore any portion of the damaged property or disturbed from testing or other evaluations to a condition equal or better than the condition it was prior to the testing and evaluations. Because this is still the seller's house. Due diligence period is subject to due diligence period. Then the agreement shall be an option contract, which time the buyer shall have the option for any reason or no reason to terminate this agreement upon notice to the seller given prior to the expiration of the due diligence period, in which case buyer shall be entitled to return buyer's interest without penalty, earnest money without penalty. So yeah, basically it's an option contract in the beginning as long as you're in due diligence. You have the option to buy at that price if everything looks good. All right. Seller shall disclose to any buyer any known latent or hidden defects in the property that could not be discovered by the buyer during a reasonably careful inspection of the property. Warranties transfer. Seller agrees to transfer to buyer at closing any other warranties such as a contractor's warranty, etc. Repairs. All agreed upon repairs and replacements shall be performed in a good and workmanlike manner prior to closing unless otherwise agreed in writing by the buyer and seller. All right, lead-based paint, if you have that. I'm not going to get into the agency stuff. If you don't know all the different agencies, it should only be client. Don't do dual agency, all that stuff. The buyer and seller shall be pay their respective compensation obligations. You have to do that in closing and all the formal paperwork. Just to make sure all of the agents are not acted shady or have other motivations, shall we say. Time limit of offer. Obviously, you had the time limit on there of how long the offer is good for. And you often have to go back and forth on negotiations. Until both sides agree, then that's when it comes up. Remedies of seller. In the event that this agreement fails to go through due to default of the buyer, seller's sole remedy shall be to retain the earnest money as fully liquidated damages. All right. So that's it. The only thing that the seller can get is the earnest money. Now, the remedies of the buyer. In the event that this agreement fails to close due to the default of the seller, buyer may 1. Seek the specific performance of this agreement, which is make them go through with it. 2. Terminate this agreement upon notice of seller and holder, in which case all earnest money, deposits, and other payments buyers has paid toward the purchase of the property shall be returned to the buyer following the procedure set forth herein. And the buyer may pursue any remedy under risk of damage to property. Seller warrants that at the time of closing property and all remaining property will and be substantially the same condition, including conditions disclosed in the property disclosure statement. So yeah, if you go and do your final walkthrough, for example, I highly recommend your water heater is busted. You do not have to go through with it because it's not in the same condition. So I always recommend that final walkthrough, just in case. Duty to cooperate. All parties agree to do all things reasonably necessary to timely and in good faith fulfill the terms of this agreement. A lot of things in real estate are very time oriented. No authority to bind, which means the broker cannot sign for you. The binding agreement date shall be the date to which the party transaction who has accepted an offer or counter offer to buy or sell real property delivers notice of that acceptance. We'll show you what that is in a minute. Rules for interpreting this agreement. Handwritten changes shall control over pre-printed or typed provisions. Exhibits shall control over the main body of this agreement, and special stipulations shall control over both exhibits and the main body of the agreement, including handwritten changes here too. Times of the issue in this agreement. Those are just definitions of stuff. Cyber fraud or prevent fraud. I'm not going to get into all that right here. Limit on broker's liability. The broker shall have under no circumstances have any liability greater than the amount of compensation paid. These are going to be all the forms, etc., that are going to depend on your specific transaction. It's where the buyer's signature, seller's signature. There they are again. If you have more, that's where they go there. That's where the agents go. And this is the binding date agreement. So once both sides actually agree, this is the last one to sign it in. Well, unfortunately, I can't share this with you. For our viewer's sake, please correct me on anything if I did wrong. If you learned something, please like, share, comment, or subscribe. If you have any questions about Georgia real estate or construction, my contact information is below. This Investing in Georgia. I am Alan. Thank you.